Okay, today's webinar is taking title to real estate and clouds on title, including liens and how to deal with clouds, what they are, etc. Um, so just a couple of the kind of preliminary materials on every webinar. Today's presentation materials are copyrighted by my office, so please don't reproduce this and sell it. It is always available for free on my website. So if you ever need to go back and review the material, just go to the website, click on the free webinars tab, and then you can not only find out about all the upcoming webinars that we have scheduled, but the video recordings of all previous webinars. So you can always go back and look at this material, so there's really no reason to steal it. Thanks for attending today's webinar. As always, this information is general information for your education purposes. It is not specific financial, accounting, or legal advice. Everybody's situations are different, so make sure that you take this information, and if you've got specific questions, just give our office a call, and then we can advise you specifically about your situation. So just be aware of that. Okay, most of you already know me, but I think there's actually a number of people on the webinar today that don't know me. I've been an attorney since 1995. That actually is now at 19 years since we were in 2014. I've created over 500 business entities, worked with well over 500 clients in various industries, though most of my clients are in real estate investment. I've been a personally real estate investor since 2000. I was a licensed real estate agent for 8 years. I am a title and escrow officer, and my law office does offer escrow services. Been an entrepreneur, small business consultant, educator, published author, coach, and athlete. Those are the personal things about me. So if you have any questions and want to chat about those, I'm always happy to talk as well. What our office mostly does is entity formation and asset protection. We take a complete view of your life, both corporate and personal, when we design plans in asset protection. We do corporate consulting and real estate investment consulting, title and escrow works, business and real estate transactional documents, fiduciary services. What this actually doesn't include, we also do estate planning, so family wills and trusts, powers of attorney, and healthcare directives. We do quite a bit of that as well. And of course, we have our live education series and our free webinars. Okay, today's agenda. We're going to talk about a couple of the two most common ways to take title and the differences between them, and the pros and cons of taking title either as joint tenants or tenants in common. We're going to talk about transferring title and the different kinds of deeds you use to transfer title and which ones you should use. Then we're going to talk about liens and the reconveyance, and then the notice of interest and release, plus some additional clouds on title like mechanics liens and lease pendants. So that's kind of today's agenda. So let's go ahead and get started. Joint tenants. This is the most common way that more than one owner will take title to property. In fact, about 80% of all titling that is done when there's more than one owner, they are joint tenants. And the biggest feature of a joint tenancy is called the right of survivorship. And this is an important distinction because tenants in common don't have this right of survivorship. The right of survivorship means that the other owner or owners of the property are or become the heirs of each other. So if one member or one owner of this property that's owned as joint tenants dies, then that person, the deceased's ownership in the property automatically, so this is automatic, it just happens, automatically passes to the other heirs or to the other owners of the property and not to their personal heirs through a will or family trust. This is really the way married couples will take title. Because in the event of the death of one of the spouses, then the title automatically passes. And the nice thing about this is that it passes automatically, and it's a little bit easier than having to go through probate or something like that. only humans can be a joint tenant. So you cannot be a joint tenant with an entity or a family trust. And the reason being is that entities that have family trusts don't die. And so they would always be the final survivor of the property and would take ownership, because at some point all the humans would die off. So this is a way that two or more human beings can take title to property when they want this right of survivorship. Also with joint tenants, the ownership is not divided. Each owner has an equal right to possess and enjoy the property. So each joint tenant essentially owns 100% of the property. So if I have a joint tenancy with a partner, I own 100% and then she would own 100%. So we both each own 100% of the property. However, one thing that a lot of people don't know, if you do own property as joint tenants, that ownership can be transferred. Now notice that I said ownership can be transferred, not title. So title does not, one joint tenant can't transfer title, so they can't sell the property. But one joint tenant can transfer their interest in that property to somebody else, or to a family trust or something like that. In this event, if that owner does transfer their interest to another party or to another entity, that can automatically redefine the tenancy of this property and take it out of joint tenancy and make those current owners then tenants in common. So you could lose this right of survivorship if one of the owners transfers the property or the rights to the property to somebody else. Again, typically this is the way that married couples take title, but marriage is not required. Any two human beings can take title to property as joint tenants. You can add children on there, and when mother and father die, their rights to that property can pass to the children, who then will own it in proportion to the number of owners. So again, it is a way of transferring property automatically to the other joint tenants and avoiding things like probate. And the benefit is, like I said, not only can it avoid probate, it can avoid some estate taxes. So a lot of people will put perhaps a vacation home in the name of multiple joint tenants, husband, wife, and children. And when husband and wife dies, that property can pass to the children and avoid some of the estate taxes. So it does have the benefit of that. It can also pass upon death as an automatic transfer. So, and particularly as real estate investors, this is important. Is if you're working with, you're looking at a property, a deal, and you're thinking about buying it, and it's owned by title in the name of the husband and the wife, but the husband is dead. If it's truly owned as joint tenants, and husband and wife, and husband is dead, all you then need is the death certificate. And with that death certificate, the remaining spouse can then sign your closing documents and sell the property to you. You don't need a court judgment or anything else. All you need is that death certificate. Take that into your title company, show that one of the spouses is dead, and that the title is held in the name of both spouses as joint tenants, and you're good to go. So it can make things really, really easy for husband and wives and transferring the property when one of the spouses has passed away. Some of the risks, though. A lot of real estate investors really don't like joint tenancies, because it's not real great for asset protection purposes. And most real estate investors are looking at property not as residences, but as investments. And so real estate investors are typically more interested in asset protection than transfer upon death and ease of transfer. So some of the risk in a joint tenancy, like we said before, one of those joint tenants can transfer her interest without permission of the other joint tenants. And in that event, then suddenly all of them will become tenants in common, and you'll lose that right of survivorship. Also, a joint tenant's interest can be subject to that joint tenant's creditors. So if one of the people on title as joint tenants is sued, the court not only can attach their interest, but the court may force the liquidation of the entire interest. Because remember, a joint creditor owns, in a legal sense, 100% of the property. There's no division of that property among the joint tenants. Each joint tenant owns 100% of the property. So a court can force the liquidation of that property and force the sale of it to take the debtor's share of profits from the sale. So it's not a great asset protection tool. In fact, there's almost no asset protection whatsoever in owning title as joint tenants. So our general recommendation is using an LLC or a family limited partnership. The other issue with joint tenants is you have to remember that whoever lives the longest gets the property. Because remember, all joint tenants become heirs, so to speak, to one another. So the last to survive is the one that takes full use of the property. And that may or may not be the goals that you have when owning property with others. So joint tenants, the way to kind of remember that, I always think of JTROS, which stands for JTROS, or joint tenancy with rights of survivorship. And it's the husband and wife way of taking title. Now, most of you as real estate investors, when you take title, you're almost certainly not going to take title as a joint tenant. You're going to take title as a tenant in common. With a tenant in common, there is no right of survivorship. So one owner's rights pass to their heirs. When you take title this way, and partner A dies, then partner A's rights to that property pass to partner A's heirs, his wife, his children, his mother, whoever is listed either in his will or his family trust or by state laws of succession. And so suddenly you will find that you now have another owner of this property who isn't the person you went into the deal with at the beginning. And you can't control that. You have no control over that. Whatever happens, whatever that owner either wants to do with the property, or if they die, that it's going to pass according to their estate. Humans and entities can take title this way. Typically when clients maybe are doing a joint venture agreement, and so there's two entities and they're each going to own title, they'll take title as tenants in common. But humans can do it as well. You can be a tenant in common with another human being. And sometimes spouses will take title this way because they don't want it to automatically pass. Maybe they're worried about divorce. Maybe they're trying to, maybe it's a blended marriage and husband has one set of kids and wife has another set of kids. And so they don't want it to automatically pass to the other and possibly the other spouse's children. And so they want to keep that division clear. And so husband and wife can take ownership as tenants in common. In this case, ownership is divided. So there is a clear percentage ownership that each owner has rights to. If there are two owners, it could be 50-50, it could be 90-10, it could be 99% to 1%. But ownership is divided and clearly established, and so that you know at any given time what percentage ownership you have in this property. But even though the ownership is divided, all owners have equal right to possess and enjoy the property, just like under the joint tenancy. So all these owners can use the house, live in the house, receive rents from the house, etc. And that ownership can be transferred or passed by will or trust. Because these are, in tenants in common, it's very much like a discrete property interest that is yours to own and control. You can sell it, you can transfer it, you can pass it by your will or family trust because you sort of own it, and you can do that without the permission of the other owners. So what are the benefits? It's certainly better for partnering. So if you're going to be partnering through like a joint venture agreement with another real estate investor, it is very common for those two entities to take title as tenants in common. There's another way to do it. We're going to talk later about using a notice of interest, but that's another topic in just a few minutes. You can control your interest through titling, wills, trust, sales, assignments, pledges, whatever you want. And the other benefit is that the interests are separate for asset protection. So in the event the other owner is sued or goes into bankruptcy, the court or the bankruptcy trustee can access that person's membership or ownership interest, but they cannot force the sale of the property because you have a certain percentage ownership and so does the other person. So the only thing that the creditors get or the bankruptcy judge would get is rights to that person's interest. But the asset itself is protected. It's protected in the same way a multi-member LLC would protect the asset in there. And again, the reason is we're protecting the innocent party. Since in tenants in common, there are two or more clearly defined owners with percentage ownership, we are protecting the innocent parties from bad acts, lawsuits, judgments of another party. So a much better way to hold title for real estate investment purposes. So most likely you will be doing tenants in common. The risks is that you can end up with other owners. Because each owner owns their interest, they can assign it and pledge it and sell it or whatever they want to do. So suddenly you may have other owners on this property that you have to deal with. So what is the takeaways from these two different ways of titling? Use family trusts for estate planning purposes, right? Family trusts work much better than just doing joint tenants with a husband and wife. Or blended marriages, that we talked about, that they may want to do tenants in common because they don't want the full property passing to the other spouse's children. But a family trust can take care of all of that. So for your own, especially for personal residences, you definitely want to create an estate plan, have a family trust, and have that family trust own your personal residence so that it can pass without probate to the persons that you'd like it to pass to. Then for partnerships and investments, use an LLC or a family limited partnership. Again, because what this not only does is it takes title in a way that provides asset protection, but that LLC or FLP will have documents defining the relationship between the owners. If you took title just as tenants in common, you're going to have to battle everything out. You're going to have to discuss, do you lease it or do you sell it? Who's going to manage it? Who's going to rehab it? Who's going to list it for sale? And all of these things. These are decisions you should have to make day by day with whoever you own that property with. But if you create an entity to take ownership of that property, that entity will define the relationship between the two of you. And it's a much cleaner, clearer way to manage that property. And of course, for asset protection, we use a combination of all of the above. We'll use family trusts, land trusts, LLCs, family limited partnerships, and corporations, sort of specifically designed to your situation to maximize your protections. Okay, transferring title. These are the three sort of main ways that we transfer title, by general warranty deed, special warranty deed, or quitclaim deed. A general warranty deed is the most protective because it comes with a number of warranties. It warrants that the seller has clear title, that there are no liens, and that title is protected from third-party claims. Most real estate transactions will always be done by a general warranty deed, so make sure that you always get a general warranty deed. A special warranty deed is less protective. In this case, the seller only warrants that he has received title and that the only liens that are there are the ones that are listed. So you're not really getting assurances that there's no problems with title, there's no other clouds on title, there's no other claims from perhaps heirs or children or spouses or just somebody else down the line. Usually this is only done to transfer title to an executor of an estate or a trustee of a family trust. So what they're really doing is just giving another person the ownership of the property to either use or manage during the time period that he or she is the executor or the trustee. that we really wouldn't do a special warranty deed when transferring title between a buyer and a seller, for example. And a quitclaim deed is the least protective of all because it has no warranties. And not only does it have no warranties about title or liens or clouds, it may even void previous warranties and warranty deeds that were issued on the property. Never use. That is my recommendation. Never use a quitclaim deed ever. There's no need. You can do a warranty deed without an insurance policy. So why would you do a quitclaim deed? And I know a lot of title companies and investors, they'll just do, because they'll have the documents, so they'll just drop a quitclaim deed. But there's no reason to. There's no real reason to ever use a quitclaim deed. Always use a general warranty deed to transfer title. Even when I take with clients and they have to buy a property in their personal names and then they just want to transfer it to their LLC for holding purposes, yeah, we use a warranty deed, not a quitclaim deed. A couple other deeds you may run across, a bargain and sale deed. Again, this is something that you usually purchase in a foreclosure or maybe a tax lien sale, where you sort of bargain for and paid some amount of money to get the deed or title to the property. It doesn't come with warranties. You take it subject to everything else that's there. So investors that do foreclosures and tax lien sales are usually very educated and sophisticated investors who are comfortable taking this property, possibly subject to who knows what. Trustee's deed, comes out of bankruptcy, and usually you will take it also with liens on the property. I have a number of clients that actually buy trustee's deeds, and they do take it subject to the liens, and then once they're the owners of the property, they negotiate short sales or some other arrangement with the lien holders, the banks, to either pay them off or get rid of them. But again, you can get a trustee's deed, and that's a transfer of title through a bankruptcy. And the other one that we just got listed there is a trust deed. Now, most of you know that a trust deed doesn't transfer title; it is actually a lien. But since it has the word deed in it, I thought I'd list it here just to kind of clarify that a trust deed is not an ownership document. It is an evidence of promissory note and lien against the property. So some of the takeaways from transferring real estate: always get an owner's policy of insurance. This is kind of standard in the real estate investment profession. We just know that anytime you take title, always get an owner's policy of insurance. And reasons why is, you may do a quick search online. You may be able to read the county records, but a title searcher will go probably further back in time. They'll be more sophisticated and experienced at reading titles and the different liens and clouds, et cetera, that are on there and whether or not they've been released. We will also do a personal search on the seller for judgments against the seller. And then certainly I do it when I do closings on clients, we have affidavits about possible hidden liens. For example, if you go to buy a property from a seller, that seller may have done something in the previous couple of weeks. Maybe they had some work done, replaced a roof, or had a contractor come out and who they haven't paid. And so there's the possibility that a mechanic's lien may show up after closing. And so what we do is we have the seller sign an affidavit that they haven't done anything to the property that might incur a future lien on the property, because nobody would know about it at that point except the seller. And so that affidavit that can then be taken to court and force the seller to pay and remove that lien. So there's definite benefits to always going through an appropriate title company and getting an owner's policy of insurance that will insure you against problems on title. I've had 3 clients in this year, so far in 2014, need to call in their insurance and have the insurance company defend them against something. So it does happen. It may not happen a lot, but it does happen. And without it, you're looking at thousands and thousands of dollars, if not tens of thousands of dollars in attorney's fees to clear up whatever problems might arise. And it's so much easier to call the title company and have their attorney then take over the case. Okay, liens. First, kind of a definition of lien. A lien is an interest in the property, secure in a debt or obligation. There are voluntary liens, such as a trust deed. Voluntary lien is when the owner of the property voluntarily allows a lien to be put on their property. If they want a loan to buy it, or they get a HELOC loan or a second loan, they're allowing that bank or lender to place a trust deed on their property to secure that note. There are involuntary liens. These are liens that are placed on properties without the owner's permission. Mechanics liens, judgments, tax liens, HOA fees can be liens, notices of interest, and believe it or not, attorneys. Attorneys we write the law, so we make them convenient to us, and we actually can put liens on property if we don't receive payment. So always pay me. And then there are judicial liens. These are liens that are put on by court order. For example, divorces, child custody suits for back child custody. But there are a number of reasons why a court might place a lien on a piece of property. Okay, the most typical type of lien is the trust deed or mortgage. In Utah, we pretty much use trust deeds, but other states will place mortgages, but they're the same thing. This is a lien placed on the property by a lender or a bank to secure the debt. And that debt is usually evidenced by a promissory note. So it's called very often a note and deed. The note is the loan instrument. It defines the terms of the loan, amount, interest rate, term, points, payback, etc., whether the interest rate is variable or fixed and all that. That's the note. And then that note is secured by the trust deed. Kind of a word that a lot of people may not know is holder. Remember that notes, these promissory notes, can be transferred, they can be assigned, they can be bought. In fact, many of my clients buy notes on the open market. And so the holder is the current person or entity that can enforce the note. It may not be the original lender. It may be somebody multiple lenders down the road. If you've ever dealt with mortgages and banks, you know that very often their loans are sold to other servicers. So whoever the holder is the person that essentially owns the note and has the right to enforce and foreclose on the note. A trust deed is released through a reconveyance. So if you do search county records, you might see words or letters like TD. Okay, that stands for trust deed. That means that there is a trust deed placed on the property, and they'll give you information about that. And then later down the county records, you may see something called recon, which is a reconveyance. So you can then search that reconveyance and see which trust deed was released with that reconveyance. And so that's a way of kind of searching title and figuring out what deeds have been placed on the property and which ones have been released through a reconveyance. To get that reconveyance, that is usually a request from the lender, and it usually comes with a payoff. So as a title company, we would get a request for payoff and a reconveyance from the lender who tells us exactly how much the loan balance is, and as soon as we pay them, we are then allowed to reconvey that trust deed and essentially remove it as a lien from the property. Okay, a notice of interest. This isn't necessarily a lien. It is a cloud placed on the property by somebody with an interest in the land in order to secure their rights. It does not have to have an amount. It does not have to have a promissory note. There are many ways many things that can create an interest in that property, which can then be secured by a notice of interest or NOI. If you have a REPC on a piece of property, a lease option, promissory note, even just a general promissory note that you did with your friend or your family member, a joint venture agreement. Many of my joint venture agreements, for titling reasons, will title in the name of one of the joint venturers, so one of the investors. Then the other investor, instead of putting that investor on title, will actually just have them secure their rights to the profits from the joint venture as a notice of interest. Okay, and really any other contract that creates an interest in land can be secured with a notice of interest. But a big note here, and that is called a wrongful NOI or wrongful lien. This is state statute. So this is something that is very serious and very actionable in court. Do not put a notice of interest on a piece of property unless you have something in writing that says you have some kind of interest in that property. So let's take some of these examples from above. A REPC. Obviously, a REPC is the purchase contract to purchase a piece of real estate. On that REPC will list the address, okay? And you will sign it as the buyer, which means you have the right to buy that land. That's good. That suffices. That REPC does create an interest for you in the land. If you have a lease option, the lease option gives you the right to lease the premises, okay? Maybe not buy it at that point, but you do have this option to buy it in the future. That is a right or an interest in that land, in that property with that address, and you can record your lease option and or a notice of interest stating that you have this lease option. Promissory note. If you have a general unsecured debt with a friend or a family member, and if you're ever thinking about doing it, and you first put it into writing. Don't ever loan money without putting it into writing. That is your golden nugget number one. Don't ever loan money without it evidenced by a writing. Second, even if the loan isn't for anything to do with real estate, write on that note that this loan creates an interest in, and then state at least the address of the property. Preferably the legal description, but at least the address. Because you want that promissory note to evidence an interest in land so that if they don't pay it back, or if you're worried they're not going to pay it back, you can then secure that with a notice of interest, maybe on their personal residence or something like that. But that note has to reference that this note creates an interest in land and at least the address of the property that you want to secure it by. If you don't, if your document doesn't state that, and you don't have anything in writing that says that the holder of this note or this buyer on this REPC has an interest in land with an address, you cannot just go slapping NOIs on land just because somebody owes you money. That would be considered a wrongful notice of interest. The owner of the property can sue you to remove it, and they can sue you for triple whatever their cost is to remove it. So if they have to hire an attorney and sue you to remove that notice of interest, and it costs them $5,000 in attorney's fees, you would then owe the seller actually $15,000. $10,000 of it would be profit for the seller. So the seller can actually make money on this to sue you to remove that notice of interest. So this is not something that can be used lightly. It is a lien, it is a cloud on title, and it will prevent the seller from selling it. And you're not allowed to encumber people's land just for any reason. Okay, so on all of your documents, promissory notes, whatever it is that you think you may want to secure at some point with a notice of interest, just make sure somewhere in that writing it states that this agreement, this contract, this option, this purchase contract creates an interest in land which may be secured by a notice of interest. And then you're good. And you can do it. Notice of interest are released by a release. In other words, whoever put the notice of interest on can just file a release of notice of interest. And that notice really it doesn't have to state an amount. All it does is kind of put on notice that there's somebody that's got a financial interest in this land. And in order to remove it, if it's a valid notice of interest, when the seller tries to sell it, the title company will say, hey, there's a notice of interest. We can't transfer title until it's cleared. So you better talk to the notice of interest holder and negotiate and find out what it's going to take for that notice of interest holder to release that notice of interest so that we can sell the property. So it really kind of becomes a negotiation. You can put amounts down, but again, you don't have to. It's really just to sort of hold your place in line. Okay, I guess that's a good way to put it. Okay, so that's a notice of interest. A lease pendent or lien pendent. Okay, this is a notice of impending lawsuit regarding an interest in the property. Um, this is really, it acts just like a notice of interest. And it is just sort of putting people on notice that this property is subject to a lawsuit. It can only be filed after litigation has started. So you can't put a lease pending on a piece of property, in anticipation of possibly suing the owner for damages or for the sale of the property or for whatever it is that you want to secure. You must actually start litigation. You must actually file a complaint with a court of competent jurisdiction and serve the owner or the person you're suing and saying, okay, here's a lawsuit. It's about this property. And then you can put a lease pendant on it to provide notice to any future buyers or title companies, et cetera. Sheriff's levy and other court-ordered liens. Just a quick example. I did a closing last month, and we went to close and we ran title and we saw that there was a sheriff's levy on the property. So when we researched the sheriff's levy, and the property was held in the name of a family trust, and the owner of the trust, the grantor of the trust, was the mother of this family, and she had already died. And one of the daughters was the trustee, and the daughter was trying to sell the house. And there was a sheriff's levy on there, and so we looked it up. And a son, essentially the brother of the daughter that's the trustee, the son had been previously married in the 1980s and skipped out on his ex-wife and their child, and 25 years didn't pay child support. And so the mother, we call her the baby mama. The baby mama sued her ex-husband and for 20 years, and by 2013, it was up to about $150,000 in back child support, fees, interest, et cetera. And what happened was the baby mama's lawyer somehow found out that this son was a beneficiary on the trust to this property, or maybe that he had lived in the property at some point, so they had an address. But as soon as they got the judgment from the court that the baby's daddy owed the money, the baby's mother's or her attorney immediately slapped a lien on this property. Now, it was a wrongful lien because that property was not owned by the husband. It was owned in a trust, and so. But because they just put it on there, we had to get it removed, and it had to be removed for court order. So we had to make a petition to the court, prove to the court that the home was actually owned by a trust, not this baby daddy, and that the baby mama had no rights to put that lien on there. And it was easily done. I mean, we went to court, we showed them a copy of the trust, we showed title in the name of the trust, and the judge said, okay, done. And then the judge ordered a removal of that sheriff's levy. But it took about 3-4 weeks, so it delayed our closing, and it cost the buyers some money to pay the attorney to remove that sheriff's levy. So things like that happen, and so be aware of them. Okay. Next, mechanics liens. This is a big topic. There are now a number of hoops that a contractor must jump through before placing a mechanics lien on the property. They have to register with the state. They have to do a preliminary notice. Then they have to do a notice of lien. Then they actually file a lawsuit to foreclose. There's time frames and time limits and other sort of legal and court hoops to jump through. Courts consider this a privilege, not a right. So again, it's getting a little tougher for contractors to put mechanics liens on, which is good for property owners like most real estate investors. But if they do go through that process, then they can put on a lien, which would then need to be removed. And it's the same if the contractor didn't jump through these hoops, or they didn't have a right to put that lien on there in the first place. Maybe they were fully paid. It can be considered a wrongful lien, just like a wrongful notice of interest, and you can sue them to remove that mechanics lien and get treble damages. In fact, I had a client just earlier this year called up and said that he had a contractor that skipped out on him, ruined things, made things worse, didn't do what he was supposed to do, took a lot of the payment up front, didn't even do the work that he'd actually been paid for, and then tried to turn around and essentially strong arm my client into paying him more money, trying to claim that he did other things, and he slapped a lien, a mechanics lien on the property. Well, I called up the contractor, laid into him, told him that that was a wrongful lien, that I would file a lawsuit immediately to have it removed, and I would go after treble damages. It was cost him 15 grand if he didn't remove that in a couple of days. And the contractor removed the lien because he knew that he didn't have the right in the first place, because he didn't even jump through the right hoops. I mean, irregardless of what he claimed he was owed monetarily, he didn't jump through the right hoops. So he had no authority to put that mechanics lien on the property, and he just removed it. So again, it works the same as the notice of interest. You must have the right to place the lien on the property before you place it on. Okay, lien takeaways. Good title search. Learn how to read county records. Some counties charge you money to get on and search the county records. Other counties are free. You can probably be aware of that and research that. But I would go to the free counties. Utah County is free. So go down to Utah County, get online, just start pulling titles for different properties and learn how to read county records and do a good title search. Be aware during the entire process. Liens, especially notices of interest and mechanics liens, bankruptcy judgments, lawsuit judgments, creditor judgments. These can pop onto title at any time. Do a real closing. When you do buy something, do a real closing. Use a title company and get an owner's policy of insurance. Those are the safest ways to take title, and then you're covered. Like I said, I've had 3 this year. A lot of people think, oh, I'll never need title insurance, but guess what? When you do, it'll save you more money than you paid on title insurance, probably on your last 10 transactions. So definitely worth it. Also remember, kind of as we close up here, you're investors and you're buying great projects. These are properties with distressed sellers, and distressed sellers give you great prices. This is what you're looking for. But remember that distressed sellers are distressed. I mean, there's a reason why you're getting a good deal. Maybe they are anticipating bankruptcies. Maybe there was a recent death and it's an estate. Maybe they just went through a divorce and they've got all of those costs. Maybe they've been sued, or there's somebody's thinking about suing them. So there's reasons why sellers are distressed, and those distresses can cloud the title. So the more educated and aware you are, the more likely you can make your deal happen, even in those events. Okay, that's sort of the end of this webinar, but just wanted to tell you what's about coming up. The September webinar is the Series LLC. It's all you need to know. We're going to cover not only how it works, but how to run it. So that's Tuesday, September 2nd at noon. So be sure and register for that September's webinar. And then our partnering superclass. It is a partnering class, but believe it or not, we're going to cover a lot of seller financing. I found that I get more questions on seller financing than anything else. I find that very few people understand seller financing and the different ways to seller financing. But you got to remember that seller financing is partnering with your seller. And it's a very long-term partnership with your seller. And there are financial arrangements and managerial arrangements that you need to be aware of. So in the sense of partnering with sellers, we're going to cover lease options, contracts for deeds, which I'm not a fan of, seller financing, subject twos, wraps, AITDs, that sort of thing. So we will cover seller financing. We'll cover partnering with other investors, partnering with contractors, partnering with hard money lenders, and how to do that. The risks, the rewards, the different entities you can use, whether it's a joint venture, an LLC, or a partnership agreement. Taking title, so in these partnership ways, how you want to take title. We'll talk about due on sale clause, problems when you can't get along with your partner, what if your partner dies, goes bankrupt, and much, much more. It's a 3.5-hour class on Saturday, September 20th at 9 a.m. at the Miller SLCC campus. You can register through the website or by calling the office. So those are things we've got coming up. I hope you have a great day and week. I'm off on vacation, so that'll be fun, and I will talk to you all soon. Have a great afternoon. Questions. Now I forgot to ask that. But if there are questions, I'll certainly take them. I didn't see any pop up during my webinar, so I'm assuming that I explained things very, very well. But if you've got a question, you can go ahead and type it in the question field or raise your hand, and I'll see if I can turn on your mic. So I'll give it a second or two to see if anyone's got a question. Oh, also FYI, if you want, I have a PDF document on mechanics liens, because it's quite complicated in the hoops to jump through, which is, I mean, it would take an hour just to kind of describe mechanics liens. But if you want a copy of a PDF document describing the process to place mechanics liens on your property, just email the office and we'll send it to you. It's good to know, even though most of you are not contractors and aren't thinking about putting on a mechanics lien, the more you know, the more you can prevent your contractors from putting a mechanics lien on there. Because if they don't do it correctly, you can force them to remove it. And if you know that the hoops that they're supposed to jump through and you know that they didn't jump through those hoops, that's power. That's power for you to get them to remove that lien. So just email the office and we'll send you that PDF on mechanics liens. Okay, not seeing any questions. People are starting to jump offline, so they're done with their lunch break or they're going to go eat lunch. So have a great day, and just let us know if there's anything we can do for you by giving the office a call or sending me an email. Thanks.